everybody. I expect that some people are going to roll in over the next few minutes, but I'm going to go ahead and start now. My name is Blaire McClanahan. I am one of the attorneys here at Cheryl David's office. I also have the distinct honor of being Cheryl David's daughter, so we are quite the family business over here. We handle estate planning, asset protection, and administration after somebody has passed away. Those are really the only three areas of law that we handle here. So while we can't help you with your traffic ticket or your divorce, we do this one area of law just so very well since we've been doing it for over 30 years. So today's webinar is going to be about 60 minutes. We're going to talk primarily about estate planning, trusts, powers of attorney, wills, and also asset protection in the event that you get sick. That is one of my focus areas here, in addition to estate planning, is working with families where there's been a bad diagnosis. And unfortunately, somebody has to go to the nursing home. As everyone here is probably well aware, or as you're about to find out, nursing homes are very expensive. I don't think that's a surprise to anybody. And we quickly see people just go through everything that they've earned in their life so quickly. So we have an entire department here focused on making sure that your family does not lose your nest egg. So that is one of my focuses here, in addition to the other areas that I've spoken about. We have a few amazing attorneys. So another attorney here is Justin Plummer. So he does handle estate planning as well as probates and trust administrations when someone has passed away. Anyone who has attended this webinar is entitled to a free personal consultation with any one of the attorneys. We don't necessarily know when you're signing up who that's going to be with, but one thing I do want you to make a note of, if you are here specifically for asset protection, please put that in the notes so that we can make sure that you are with the right person. All right, well, I'm just going to go ahead and get on in it. And we have a video that we would like to share with you with some of our most favorite clients that we have.
I got a dreaded phone call. My sister was in intensive care. We made it up there and she passed away. She had contracted bacterial meningitis. And the thought that I can lose somebody so dear to me so quickly was devastating. And it made me rethink absolutely everything, but especially my career. Realizing that what we went through with my sister was something that happened to people every single day. And I thought if I could be of help when people are going through that horrible time in their life and make it a little bit easier.
My husband, Wiley Harris, passed away in 2017. And then I realized I needed some help. The human aspect means a lot to me. And some places are business, business, business to the end of the day. But they have been very conscientious and they have led me into the right direction. She got some great people working with her. I just have full faith and confidence in the staff.
It's very special to me that we help families, but we're also a firm that's comprised of a family. It's myself, it's my daughter, Blaire, the other attorney that I work with, Justin Plummer. He's like family. The clients respond to this family atmosphere, and I think that they can feel that we really care.
Well, I wanted to ensure that my family would be taken care of.
We also first met Cheryl through his mother, who came basically to live with us after his father passed away. And so we would try to make it simpler when it came time for us to deal with her.
After we met Cheryl, she gave us the ropes and transfer of the estate in a matter of weeks.
But no one wants to talk about death, but it's something that's inevitable for each and every one of us. It's smart to come in and have a conversation, because if you don't have a conversation, you're not protecting those that come after you. We recommend that you come see us at the law offices of Cheryl David, and we'll sit down and we'll listen to you. and we'll try to come up with the best plan that we possibly can.
Thank you so much for sitting and watching our little video. And to anyone that's new, welcome. Again, my name is Blaire McClanahan. A few ground rules for today's webinar. I mentioned earlier, but this is going to be about an hour. Please jot down any comments or questions. There should be a chat that I believe is at the bottom of your screen. We actually have an attorney live on here with me who is going to be answering any questions that you have. There is a way to make those questions private and only ask the presenter. Otherwise, everybody can see it. So just make sure not to put too much private information in there. Hopefully you can see me, but I cannot see you and we cannot hear you. So I hope everybody gets comfortable. Throughout this presentation, we are going to be putting a link into the chat where anyone is entitled to a free personal consultation with one of our attorneys. So if you would like to click that link, you can make an appointment. I'll be doing that throughout the webinar and at the end if you want to just listen for now. We are going to attempt to call everybody in the next day or two as well. So if you don't make an appointment, we will also give you a call. We do ask that that appointment be usually within the next couple weeks in order for it to be complimentary. We definitely would love for everyone to stay in touch with us. You're welcome to go to our website. People are always asking me, where can I get a lot of this information? And do you have, blogs or, videos that we can watch? We have just a wealth of information on our website. We recommend that you stay in touch with us. We have free reports and articles on our website, as well as an amazing newsletter. If you'd like to receive any of those, feel free to give us a little chat and we can add you to that list. We just need your email address. So congratulations. By coming here today, you've already braved some of life's hardest topics. And some of these topics that we're going to discuss today are families torn apart by ineffective estate planning. How certain plans don't work the way that we intend them to when we pass away. We're going to discuss death and taxes, as well as nursing home expenses. We find that there are three main reasons that people tend to not plan. And the first of those is procrastination. You always want to put this off. It's not the most fun topic to discuss, and we understand that. My hope is that we can give you some information so that you can make a decision on this. And obviously, our hope for everybody attending this webinar is action. So one other reason that people don't get started is lack of knowledge. There's continuous changes in the law. Maybe traditional estate planning today isn't going to cover tomorrow's concerns, or estate planning from yesterday isn't covering today's concerns. So today we're going to give a lot of information. So hopefully lack of knowledge is not the reason for not getting started. Also, law can be really complex. There's all these different types of attorney. There's probate law, tax law, trust law, real estate law. It's just so much information that we can get lost. So as I've mentioned, our office really only focuses on this one area of law, estate planning. And encompassed in that is planning if you get ill. What happens when you pass away? So these are all things that we're going to discuss today. And hopefully at the end, you feel like you have enough knowledge to take some action. So what are your concerns? We find the main reasons that people sign up for this webinar or ask for appointments with us is based on several. So first concern, a lot of families come to us and they want to pass on their hard-earned wealth without the government or the courts being involved. I have yet to talk to somebody that said, I really just want to give my money to the government. A second concern, how do we save money? Nobody wants to spend unnecessarily with taxes. They don't want to pay court costs. One thing that you're going to learn today is a will is a ticket to court. I want everybody to have the knowledge to make sure that they are equipping their family with the best resources to handle life after you are no longer here. A third concern, how do we avoid going broke from nursing home and other crushing medical expenses? I am sure I do not have to tell anyone on here that nursing homes are very expensive. And typically we see people just go through a lifetime of savings within a few years at a nursing home. We're talking about like $10,000, $11,000 a month. There are ways for us to protect assets in the event that this happens to you or a loved one. In fact, we have a whole department dedicated to this. A fourth concern is, how do we protect our minor kids if we are not around to do it? So today, we're going to show you the simple steps you can take right now to protect your children, even if you're not around to do it. And I must admit, I was very surprised when I did the research for this workshop to find that when parents were asked to describe the worst thing that could happen to their children, they mentioned all manner of diseases, injuries, obstacles in the lives of their young ones, but almost no one mentioned what we believe is actually the worst thing that could happen to your kids. And if you consider it for a moment, perhaps the most catastrophic event in your children's life or grandchildren's life would be your premature death. The people who love them most and embrace their dreams, who would sacrifice themselves for their benefit, are now gone. And who's going to replace you in their lives and bring the same level of love and devotion? And I love how the poet Heather Cortez puts it, to the world you may be one person, but to one person you may be the world. So do we really want the state of North Carolina deciding who raises your kids, who's going to handle their money? And maybe you attending today don't have minor children anymore, but I'm sure you have children in your life somewhere, whether that's grandkids, kids of friends. And this is just so important for everybody to have estate planning. Another concern is, how do we avoid family members fighting with each other over money? Does anyone in this audience have any family members that have some struggles? Does everyone get along perfectly? Because I find that in most families, there are some problems. And when you or a loved one passes away, that time should really be a period for bringing the family closer together. But what we see with ineffective estate planning especially is that this is a time where families are torn apart. And that is really one thing that we just strongly want to avoid when you pass away. So, what is most valuable to you? What do you want to protect? Some of our clients tell us that it's their spouse. Maybe it's their pets. I love pets, and that's something that I take in very, seriously in my own estate plan. Maybe it's your family, children, grandchildren, your health, friends, charities, business interests. These are all things that really should be addressed in an estate plan. So just to bring this all back to earth, some people like to have an example. And for you, your example is going to be Bill and Mary Jones. So I want you to meet the Jones family. They're a North Carolina couple in their 60s, and they have an estate worth approximately $700,000. They have 2 children. Susan, she is a lovely, doting daughter. She calls every day to check in. She lives just a mile down the road. She gave them 2 beautiful grandchildren. She is very responsible. By all means, she is the person who's going to be in charge of their estate when they're no longer around to handle it themselves. And then we have John. What can I say about John? You could probably tell based on the picture, he is a struggle. He still lives in the basement. He probably will until the day they pass away. This is a guy that if you give him $1, it is spent before it's probably even reached his hands. And if he were to inherit money when you pass away, you better believe this will be spent in no time. And whether it's him spending it or the people that he surrounds him with willing to relieve him of that money, it's probably not the best idea to give someone like John money outright. So Bill and Mary have some options when it comes to their planning. They could spend every last dollar. And we've seen the bumper sticker, I'm driving my child's inheritance. And if you can truly time things to where when you pass away, you don't have anything in your name, that is great. But what we find is, life is unpredictable. We have seen that over the last 4 years. And while that is a great goal, it's just good to have a backup plan as well. Another plan is dying intestate. We see this a lot in our probate department where someone passes away without a will. And if you don't have a plan in the form of a will, the North Carolina government has a plan for you, and it's called intestacy. And you might be surprised where your money's going. If you are married and don't have kids, you don't get everything. Your spouse doesn't get everything. Assets are actually divided between the living spouse and your living parents. And if there are children involved, your spouse again does not receive everything outright. Assets are split between your spouse and the kids. And oftentimes, especially in a marriage, we find that really the intent was to leave everything to our spouse. But unfortunately, unless we have a plan, and I'm not here today to knock wills, I think they're really important. We're going to talk about some other options as well, but at a minimum, I want everybody to have a will so that we can be very intentional and direct with where we want assets to go if you're no longer here. So dying intestate is not my favorite option, and a will is a really nice way to avoid this. We could put everything in joint tenancy. We see this a lot with spouses. So by joint tenancy, you might have a bank account that's in both people's names. And usually, but not always, when one person passes away, it goes to the other. Usually with our spouses, assets are set up this way, but not always. And unfortunately, if we rely on joint tenancy for all of our assets and estate planning, we have done our children a disservice because eventually the owners on this account will not be alive. And now we're stuck going through court, whether it be by a will or intestacy. And I mentioned a will going through court, and that's correct. A will is a ticket to court. In fact, a will is how the court knows how everything's divided. The court is there to make sure that that happens, that everything gets to where you want it to go, that the person that you named as the executor or personal representative is in charge. A will is very much overseen by the court. So joint tenancy really doesn't avoid court for us all the time. And I get a lot of questions, well, can I throw my daughter on my bank account or my son on my bank account? Again, not one of my favorite options, because now all of a sudden, by adding your child on your bank account, their problems are your problems. If there is a car accident, if they are sued, if there's a bankruptcy, or goodness forbid, if they are just not responsible, that money is legally theirs and it can be taken. Some of our clients create a simple will. And this is, again, a great option to make sure that at least the court knows who is in charge and how we want things divided. A good will go a step further. And not only do we name who our primary beneficiaries are, but we take it a step further and specify what if they're not alive. And we want to make sure that your will takes care of a lot of different scenarios. What if one of my beneficiaries has special needs one day? What if somebody is a minor and inherits money? So here at our office, we take all of that into account with our wills. Another option is something called a bare bones trust or an unfunded trust. So a trust, what a weird term, right? This is simply a contract. I like to say it's a will in contract form. And just like your will is telling the court who is inheriting and who is in charge, a trust is very similar. But unlike a will, a trust, when done properly, and this is not one of those scenarios, avoids court. So what is a bare bones or unfunded trust? Well, in order for a trust to truly avoid probate, we need to make sure that everything that you own is inside of that trust. So if you have a trust, it's not just enough to simply have this beautiful document. We need to make sure that your bank accounts are tied to the trust, that your house is in the trust, that your life insurance is in the trust, because everything in the trust is protected from probate. But what we find oftentimes is a lot of attorneys, especially in the state of North Carolina, they don't take that step of making sure assets get into the trust. They might give you a beautiful document and on the way out the door say, by the way, make sure you get everything in. But it is a really, really rare occasion that that happens. And all it takes is for one bank account to not be in that trust and your family is going to court. So here we take that really, really seriously. We have a complete estate plan with a revocable trust, a power of attorney, your advance directives, but most importantly, we need to make sure that your trust is funded. So if your trust is a piggy bank, And when you come into the office, you'll see piggy banks all around the room because we use this as an example. We want everything to be in the piggy bank. That is how we make sure there is no court. And for those of you that may already have trusts, and I see that we have a few clients on here today, how do we know that your trust is funded, that it is avoiding court like you intended? I tell people to look no further than your mailbox. Who are your bank statements being addressed to? Who is the tax bill for your house coming into the name of? If those are coming into your name or Bill and Mary Jones's names, it's probably not in the trust. If you see the word trust on there or trustee, it probably is in the trust, and we have avoided court. So in our example, Bill has a stroke. Fortunately, he does recover. However, with ineffective estate planning, we don't have a tool for his wife, Mary, to be able to make medical decisions when he is hospitalized. And asset protection in the event that someone like Bill needs long-term care is a huge concern. Unfortunately, Bill has a second stroke, and this time he has become disabled. In this example, Bill and Mary do not have any estate planning. And unfortunately, without a financial power of attorney and a healthcare power of attorney, two of the most important documents, in my opinion, the family is going to court. And this is going to be our first of many trips to court for guardianship. Unless you have a healthcare power of attorney or a financial power of attorney, legally your spouse, your kids, nobody can make these decisions for you regarding health and finances. It is just not legal. So the guardianship is a process designed to protect those who are mentally disabled. And it is a nightmare. I did this for the first few years of my career, and I want nothing to do with it anymore. It's humiliating a lot of time for these disabled people, especially to be wheeled into court. They don't know what's going on. They just want to be home. It's uncomfortable. People are talking about them and they can hear everything. The court is totally in control. We need their permission to do anything, to buy anything. It's time consuming. So even the months that it takes to get a guardianship in place, it lasts every year until the person passes away. And every year, an annual account has to be made to the court of exactly where this person's money was spent. And I had a case when I did guardianships where a son was named as the guardian, and unbeknownst to me and everybody, he went and purchased his dad a very simple TV for his nursing home. We're talking like $250, nothing crazy. But when it came time for him to do his annual account, the court said, hey, you never asked for permission to buy this television. He had to hire our office to petition the court for approval for this TV. And by the time that all was said and done, the attorney fees on that alone cost more than the TV itself. So what I am just trying to convey here is we want to avoid a guardianship. We want to make sure you have a financial power of attorney, a healthcare power of attorney, and we want to make sure that it's up to date. Are the people you named still the people who should be in that role? Are there contingencies? Like, what if that person's no longer here? Are there backups? And are these documents still up to date? Because there have been law changes. So in 2008, all of the healthcare documents changed. And in 2018, there actually was a change with the financial power of attorney as well. So during our complimentary meeting with you, we'd be happy to review your documents and give you an honest opinion on whether these are still working for you or not. And every day, I meet with someone and they're still fine. So that is the purpose of this meeting, is just to make sure that your plan is working for you. So we have, a complimentary meeting for anyone who wants. That's in the chat, and you're welcome to sign up for a meeting. Otherwise, we'll give you a call probably tomorrow to see if you'd like to meet. Again, with guardianships, they're expensive. The court takes a fee of $4 on every 1,000. The attorneys take a large fee. Normally I see these things range anywhere from, $6,500 up. I've seen some guardianships that are well into the 20,000 plus range because there's a fight. The accounting every year is a fee, and then the guardian gets paid as well. So it's expensive. Let's avoid it. After some time under guardianship and in the nursing home, Bill passes away. And now we are going back to court for the second time for his probate. Probate is the process to give notice to all interested parties to track down heirs, We resolve disputes. Everyone has a say. Everyone has to sign off on what they're getting. Creditors have to get paid. So we post a 3-month notice to creditor in the newspaper. That runs for a month, and creditors have 3 months to make themselves known. So when I mentioned 3 months, that's where that's coming from. After 90 days, an inventory is due to the estate where we have to show exactly what was owned by this person when they passed away. Even joint accounts that aren't going through probate still have to be reported on that probate. We have to get tax clearance. And honestly, if one thing holds up these estates, it is usually the tax clearance. Because for those people that passed away, early in the year, it won't be until sometime in early 2025 when the 2024 taxes are live. So this is our, again, #1 reason why these estates often stay open a year. And you heard me right. Probates do take about a year, and they can be expensive. And finally, at the end of the year, we can do a final account and distribute the estate. So I just want everyone to know, whether you die intestate or even if you have a will, we are looking at this process. And some people do this on their own, and some people need to hire an attorney. And we have a whole department here that can help you with this if this is you. So why should we avoid probate? Lots of reasons, but #1, it's expensive. We typically see people lose about 5% or more going through this process. The court takes a fee, again, $4 on every 1,000. That's capped at 6,000. There's publication for the newspaper. There has to be a bond. Unless you have a will that explicitly says your executor doesn't have to be bonded, there's going to be a bond, and that can run anywhere from the hundreds to thousands of dollars. And if you have no will, there will be a bond. There's an executor fee of 2 to 5%. Attorneys take 2 to 5% if your family can't do this on their own, which a lot of people can't. It is a cumbersome, complex process. So when all is said and done, 5% might actually be kind of low. And it's time consuming. Money aside, time is precious. And this thing is going to take about a year. And we need the court's permission to be able to, sell a piece of real estate, to distribute property. A probate is public. I had someone come to me earlier this week, and this was their main concern. They do not want anybody to be able to walk into the court and pull their will and all their finances. And under the Freedom of Information Act, probates are public. And there will be multiple probates, so get ready to travel if you have real estate in other cities, in other states, even timeshares. So I have a timeshare in Blowing Rock, and I have a trust, and I made sure that my trust owns my timeshare. I don't want there to be a, ancillary estate in Watauga County. It's even harder for people that are out of state. You have to confirm the will in that state and go through an ancillary estate in that state as well. And I have quite a few clients that have, maybe there's a timeshare at Massanutten, or a little piece of property in Virginia or Florida, you have a second home. These are all going to be probates in these states. And what about death taxes? So the good news in this year, you're not going to be taxed federally on an estate unless it's over 13.61 million. So for most of our clients, that's not an issue. And we can actually double that if you're married and portability is elected. It is possible that in 2025, the estate tax exclusion, it may sunset down to 5 million. My guess is with indexed inflation, it may be around 7. I just don't know. I'm not going to begin to guess what Congress is going to do. I've never been good at guessing that. So for most people, again, estate tax isn't going to be a huge concern. And the good news for everyone here, if you're in North Carolina, and hopefully you are, we are licensed to practice in North Carolina, and really, except for Justin, who does a little work in Virginia, we cannot practice outside of North Carolina. So if you live in North Carolina, you're in the right place. If you are here but don't necessarily reside in North Carolina, you'll actually need an attorney in the state that you live in. But there is no North Carolina inheritance tax, which is really nice. So after Bill dies, Mary meets Tom the neighbor. And what if she gets remarried? We often see, especially with inefficient estate planning, kids just totally disinherited, even unintentionally. And Bill's family really comes out well and possibly inherits everything. We see a lot of these, I call them sweetheart wills, where it says, honey, I love you. If something happens to me, everything goes to you. And then if something happens to you, everything goes to my kids. But if we set it up this way, I promise one entire side of the family is going to be disinherited. And it's going to be the person who passes away first. Instead of saying everything goes to my spouse and then to my kids, we need to say everything goes to my spouse and then to our kids. That is truly the only way to make sure that both sides are treated fairly. And North Carolina doesn't just allow Mary to not leave Bill anything unless there's a prenup. We have to leave our spouse assets. It's just not legal to disinherit our spouse. And if later divorced, a new spouse, like Bill, really could receive a lot of the assets, and it is not what was intended. So at this time, Mary has the whole estate. And let's say she lives 7 years after the death of Bill. I don't know how accurate that is anymore or not, but that's what our research has shown. Family assets traditionally double in 10 years' time, and Mary is fortunate, and I'm wrong, she lives 10 years more after Bill's death. But unfortunately, she gets Alzheimer's and has to be placed in a nursing home. A lot of people are, and she's unable to handle her affairs. We typically see people in nursing homes, 5-10 years, even though the average stay is usually around 2.4. And that's a lot of money if you're considering, $9, $10, $11,000 a month. We see people lose everything. And we are back in court for the third time because without a healthcare power of attorney, without a financial power of attorney, nobody can make decisions for Susan. And while we hope that the court is going to appoint her daughter, Susan, as the guardian, Mary is back in court. We hope that Susan will be appointed, but we just don't know. Without documents, John has every right to request to be guardian. And have I seen John's appointed? Absolutely. He can dress up real nice. He has no job, so he has tons of time to practice what he's going to say. He's been watching court TV, cuts his hair, and he presents really well. Oh, I live with her. I'm helping her with everything. And unfortunately, these guardianship hearings, sometimes these hearing officers are only hearing what's going on for, 10, 20 minutes. They're not getting the full picture. So yes, Johns can absolutely get appointed, and we don't want that for you. We want to make sure that we can avoid this guardianship process completely by having a healthcare power of attorney and a financial power of attorney, naming whoever the Susan in your family is or in your life as your agent if you become incapacitated. So now Mary passes away and we're back in court for the fourth time, not the final time. And this turned out to be really expensive. Overall, after going through all these probates, the family lost about $916,000. And we might be going back to court if John has issues. So nursing home stay, probate fees, we lost a lot of money at Mary's death. And without a will, again, who's going to be the executor? John has every right to step up and try to be that role as well. And it's just not what Bill and Mary wanted. And now, after the year in court, is each child ready for this huge lump sum of money? I don't think so. So everyone's worst nightmare, our kids' lazy spouse. And this is Jason. Unfortunately, when Bill and Mary passed away, Susan inherited the funds and commingled them with assets that she owned with Jason. She put the assets into a joint bank account. She put them into the house that she owned with him. And in case of divorce, he's going to get half. So with efficient estate planning, effective estate planning, we can actually avoid this process. So when we create trust for our clients, we oftentimes put divorce protection triggers into the trust so that in the event we have a situation like Jason and Susan, our money is there for Susan. And if Susan passes away, it's there for Susan's two kids, not for Jason, who may get remarried and blow all of his money and the grandkids don't get to see it at all. And as far as John, he is a walking liability factory. Auto accident, hasn't paid his taxes, he hasn't paid his bills. This money's gonna be gone before we know it. With an efficient, effective estate plan, we would have some credit shelter in there for him. He would not be in charge of his money. Maybe Susan would be in charge. Maybe their bank would have been in charge, or a trusted advisor, but certainly not John managing his money himself. And if he's not there to blow it, someone's going to be there to help him blow it. So we had a pretty ineffective estate plan here. We didn't have protection from guardianship or probate. We didn't have protection from nursing home costs. They just had to pay that $10,000 bill until the last one passed away. There was no remarriage protection for when the neighbor came around, Tom. No protection from Jason getting a divorce from our daughter, Susan. And no protection from lawsuits and creditors. And unfortunately, because we were so focused on the nightmare trash can fire that was coming in front of us, we had no way to preserve the family's life values and stories. We were so focused on all these emergencies that the family didn't really get to focus on what's the most important, which is family and the stories and your values. And there is a better alternative, and this is the trust. So why do we do planning? Why would we do a trust? We want to make sure that those assets that you worked your whole life for go to who you want, when you want, are handled by a person that we trust, and protect the people that we love most. We want to avoid a guardianship. We don't want to go through 2 probates and deal with estate taxes and paying hundreds of thousands of dollars to a nursing home. We want to avoid court battles between our kids because they're just not getting along. These are all things that can be avoided with a revocable trust. So as I mentioned earlier, a revocable trust is a contract. It's like a will in contract form. And anything that your will would normally say is in a trust. We're leaving gifts to people. We're stating how our estate is divided and who's in charge. We're putting some triggers in there. Do we need divorce protection? Do we need asset protection? These are all things we can take account in our trust. And as I mentioned earlier, the magic to a trust is how you hold title to your assets. So I mentioned, like, if the trust is a piggy bank, or if your trust is a treasure chest, we want for everything that you own to be in this trust. So you have a joint bank account, a joint money market, a joint brokerage. That needs to be inside of the trust. Maybe Bill had a little inheritance of his own. That needs to be in the trust, or maybe he's day trading. You know, we want that to go in the trust. He'll still have full access to everything. He can still day trade, but we want to make sure that his wife is not in a horrible position if he suddenly passes away, where she's now a grieving widow going through court. And same for Mary's separate property. So almost everything goes into the trust. And I say almost because there's some things that aren't obviously going to go into a trust. An IRA, or maybe it's not obvious, an IRA is not going to go in the trust. That has to be held by the individual. But what we can do is state that should your spouse pass away, and your spouse is the primary beneficiary, maybe for tax purposes, that's a good idea. But we can name the trust as the beneficiary instead of John and Susan outright. Again, they have lots of problems on the horizon: divorce, creditor issues. So by naming the beneficiary the trust, we can make sure that that protection is wrapped in there for them. So all you need to remember, on top of everything we've discussed today, but the main things I want you to know with the trust are, you are going to hold these 3 positions. You, as the creator of the trust, are the trustor or the trust maker. So this is the person who's creating and transferring their assets into the trust. So if it's your trust, that's you. The trustees, this is you while you're healthy. If this is your trust, just like I have my own trust, I am my trustee. My husband is the trustee. We are trustees together. We can manage the trust assets. While we are trustee, we can spend those on ourselves because we are also the beneficiaries while we are alive. So my husband and George and I, while we're alive, we hold all 3 of these positions. We are the trustor, we are the trustee, we are the beneficiary. We have full access to our money. If I need to take money out of the bank to, fix my roof, I can. If I need to open up a new bank account or close my account or sell my timeshare in my house, I have full access to do that. Nobody else is coming to do that job with me. When you pass away, at that point, typically people have their children, siblings, or a friend as the trustee, sometimes a trusted financial advisor. They will become your trustee. They don't get to spend the money on themselves. It is there for your beneficiaries. They may be entitled to a little compensation for that job. I find most people don't take it if they're also a beneficiary, but they're entitled to it. So again, in this situation, Bill and Mary occupy all three positions. They are totally in control. They are handling business as usual. This trust can be amended if they want. They can make changes. They can get rid of it if they want. They can still buy, sell, and refinance assets. There is no change with taxes whatsoever. They will still file how they always did. It's almost like this trust is a standby device for after you pass away. No change in property tax bills. The trust is sort of like a joint account, but it's a lot more powerful than a joint account because unfortunately with joint accounts, eventually we risk all the owners passing away and going through probate. So with this, it is, I call it a living trust. It is living with you. You put your assets in it while you're alive. And then in the event you're incapacitated, your trustee can manage just as usual. I find sometimes with powers of attorney, I don't know why banks are doing this, but sometimes they say those go stale, or sometimes they don't want to recognize it. Last month, I really had to have some strong words with a bank that was taking one of the powers of attorney that I created for a client. I know it's legal, I know it's good, and they were trying to not accept it. They can't play these games with a trust. And we can put anything in the trust and take it out of the trust. It really is business as usual. So why create a living trust? I mentioned it is a standby device to protect our family, to protect ourselves. It does not die. It does not have to go through probate. It protects us in the event that we are disabled. We can avoid the guardianship. It protects us from going through a probate and spending all that money and time in court. And we can avoid court involvement altogether. Our trust can be private, and we've protected our kids, our children's, our grandchildren's. I really should add pets on here. We can protect them too. So let's give Bill and Mary a do-over. This time they have a full estate plan with a trust. They have powers of attorney. They have advanced directives. We're going to discuss what happens with their long-term care needs. This is their to-do list on here, by the way. But unlike most people that, may want to do anything before estate planning, they've put estate planning at the top of their to-do list. Okay. So Bill has a stroke, but this time there's no guardianship. We're not going through this public humiliation. We're not spending months, possibly years going through court. Very just swiftly, wife Mary can take control. We can avoid all the court fees, attorney's fees, accounting fees. Mary is in control. And when Bill passes away, we don't have a need for death probate. Assets were already titled in the trust and just moved right on over to Mary. So we've avoided court for the second time. We don't have to appoint an executor. We don't have to pay attorney's fees. A trust it's kitchen table law for her. She can manage this without coming to an attorney. She doesn't have to spend a year going through court. I was actually on social media last night, and I saw a very sad situation where there is a young woman who lost her husband, and she has 2 minor kids, and they're setting up a GoFundMe because she has no access to the money. He had money in his own name that she did not have access to. And she's terrified because she's not going to have access to all this money for a year. Without a will, some of that money is not coming to her, it's going to her kids. So we really just want to make sure that, everyone is protected. We won't have to do the notice to creditors. We won't have to have public record by filing a will and letting anyone go and see what's been done. We don't have tax clearance holding us up, and we won't have probates in different states. Mary could just focus on, life. She's a widow. Life has changed tremendously for her, and she doesn't need to be focusing on all this. So Mary does get Alzheimer's, but this time is not going to have to go through a guardianship. Everything was set up to name Susan as her agent, so Susan can manage everything without the court slowing us down, without the court being in control, without having to pay a bunch of attorneys. Susan can just do what she needs to do. I've had a guardianship case where a woman was being kept alive, against her wishes, but she did not have a living will. She did not have a healthcare power of attorney. She had made it so clear that she did not want to be kept alive on machines, but we had to go through a guardianship, and it took about a month, and only then were the kids able to remove her from life support. When Mary passes away, again, no probate. Susan's the trustee. We don't have to do the notice to creditors, file the will at the courthouse. For the most part, Susan's smart. She's going to be able to handle this on her own. She probably doesn't even need to come to an attorney, though we are happy to meet with her. So a trust is like a tube of toothpaste. If assets are in the tube and the tube is the trust, they are protected from all the outside elements. The product is clean. Outright distributions are like putting that toothpaste on the ground, stepping on it over and over again. Once that product is out, you really can't put it back in. We can't protect it anymore. Anyone can get to it. It is best to keep the toothpaste and the assets inside the tube and give the tube the trust to Susan. Remember, we can protect assets for your children by keeping the assets and money in the trust and letting, in this case, Susan be in charge. So let's see how this works. So assets for the children are left in trust. Each child gets their distribution, but John, his money is held in a credit shelter trust that's managed by Susan. Susan has an access trust. She has access to this trust. She is in control of her own money, but it does have divorce protection in there for her. So Jason, when they break up, when they get divorced, he's not getting anything. And if Susan passes away, it's going to their kids to be held by a trusted family member or friend. Jason is not going to be in control of that money. And John has lawsuit, liability, creditor protection. The inheritance is kept safe. He's going to have an independent trustee, and his money is also protected from divorce. It's also protected from lawsuits and creditor claims. So if you have a John in the family, please let us know. We have to do some extra work. So keep the toothpaste in the tube. Let's direct how we want our trustee to squeeze out assets. And if set up properly and the money is in the trust, it can't be attached to by creditors. So again, let us know if we need creditor protection. Judgments can expire, but we don't want to just bank on that, oh, John's lawsuit's going to expire. We want to make sure that we have protections in here. We can give John a monthly stipend if we need to. That can't be attached to by his creditors. I mean, the trust could even buy a house for him. He's just not able to do what he wants independently. There has to be a middleman, and the trust can pay for his bills. If you have special needs, I really want to have a conversation with you about that. We can title assets in a way that if you have a child or grandchild with special needs, they're able to receive money, but held in a special needs trust for their benefit so that they don't lose their Medicaid, their food stamps, whatever they may be on, their disability. So a revocable trust has really given us protection for a ton of issues that we faced. We have guardianship protection for Bill and Mary, probate protection for each of them. And then I do want to spend a second talking about nursing home costs. So this trust itself that I'm talking about, the revocable trust, this is not what's giving us nursing home protection. We don't get nursing home protection like that unless we do something called an irrevocable trust. So the only trust that's giving us nursing home protection is irrevocable trust. I find that oftentimes, unless we have a serious diagnosis right now, something like Alzheimer's, Parkinson's, most of our clients want a revocable trust. They want to have access to their money. These nursing home protection trusts, we lose access. Your money is in jail. But for someone with Alzheimer's, that might not be the worst thing to do. All of the sudden, control of our assets isn't as important when we risk losing it all. However, I want for all of our clients, even that aren't doing one of these irrevocable trusts, to have the permissions in place to protect assets should that become necessary down the road. So all of our will clients who do will packages or trust packages, they get a really special power of attorney that lets us protect assets. So this is like our insurance policy. Even if we never set up one of these nursing home trusts, this power of attorney is what's going to give your agent, not me, but the person you trust, permission to protect your home, permission to protect assets. So I want everybody to make sure, not that they just have a power of attorney, but that they have the version that lets me save your house. I mean, if we are dealing with spouses where one person gets sick, with the right power of attorney, I can usually protect almost everything. And if you're widowed or single, I can usually protect the real estate plus about half. You might hear me say real estate. I heard that you can get on benefits and keep your house. That's true. But what you may not know is that when you pass away, the government gets to have a lien on your house to pay themselves back. So we could spend a whole hour, 5 hours going through this. I want to get everyone out on time. I just want you to know there are special documents that we need to have in place to have asset protection, and not all powers of attorney have this language. Okay. So even if you have one of the newer powers of attorney done after 2018, it is not automatic that these nursing home protection triggers are in there. I'm happy to review anyone's power of attorney to tell you if yours has that or not. But oftentimes, unless you went to an elder law attorney, not even just an estate planning attorney, it does not have that language. So we're going to talk about that a bit more, but again, we've avoided a ton of issues whether it be guardianship, probate, taxes, divorce, and we have immediate access to assets for Susan and for John, but by someone we trust. So for Susan's trust, she's in control. She can immediately distribute things according to her parents' wishes. She doesn't have to wait a year for the court. She can choose to hire an attorney or professional to help her, but it's not subject to court oversight. Now, I mentioned we're going to talk a little bit about long-term care, Medicaid planning. I don't want you to focus too much on the word Medicaid. I know a lot of people are like, Medicaid, that's just for people that are broke. We have a lot of clients with, significant estates that we restructure their assets so that we can get you on benefits, so that you're not having to just lose everything. Why is it fair that someone who really worked hard and saved is risking losing everything, but the person who squandered everything, maybe gambled it away or just blew it, why do they get benefits, but the people that saved didn't? So we work with a lot of families to make that more fair, to protect assets for those people who saved. And there's different ways that we can protect. Let's say, let's go back to Bill going to the nursing home. How do they pay for that? One option is using their own money. If you've listened to me at all, that's not my favorite option. These nursing homes are expensive. But after they blow through everything, sure, they can get benefits. But let's not get to that point. Long-term care insurance can be a really great option. If you have long-term care insurance, I highly recommend, unless you have a policy that truly lasts forever and is unlimited, give your attorney a call so that we can discuss what sort of protections do we need in place if that plan expires, if it's not covering the full bill. For our veterans who may be watching, there's a great benefit called aid in attendance. I don't handle that here, but this is a benefit that a lot of veterans are entitled to, maybe even now. It does require that you served in a major branch for 90 days. At least one of those days did need to be in a war, even if you weren't boots on the ground. And unlike Medicaid or disability, the asset limits for this are much higher. So, you can have $100,000 in a house and still be eligible for that benefit, which is great. And it doesn't require that you be in the nursing home like Medicaid, like long-term care Medicaid does. This is available for people at home. We get a lot of frantic calls for people asking about Medicare. They are under the impression that Medicare is going to cover the nursing home, and it frankly just doesn't. It may cover 20, 21 days in rehab, up to 100 with a copay, but it will shut off. And that's where Medicaid comes in. This is the benefit that can cover the nursing home beyond the rehab or Medicare stay. And we work with clients all day, every day. We have an entire department dedicated to it. It is something that is just so important to me. Protecting assets for your family. No one chose to get Alzheimer's. No one chose to get dementia or have a stroke. And had this been something like cancer, most likely your insurance would have covered it. It seems so unfair that these things like dementia are not covered or a stroke are not covered. So it is so important to me. I mean, it's something I'm so passionate about, is just making sure that your loved ones or you are protected in the event of catastrophic, loss. So there's some myths with Medicaid. You have to give away everything or spend it all down on health costs. False. In fact, if you were to give away assets, there is this thing called a 5-year look back. Now, as you'll see under the third Medicaid myth, that doesn't mean you have to wait 60 months to get Medicaid, but anything that you gave away within 5 years, and yes, selling your house for $1 is still giving it away, it's going to cause a period of ineligibility. So once you run out of money, the government's going to see, what did you give away over the last 5 years? That's really what that 5-year look back is. And then after you're already out of money, they're going to require a period where you still have to private pay, where you otherwise would have been eligible for benefits. So I really don't want to give assets away. There's such a better way to do it. And if this is concerning to you, let's have a conversation about this. You know, some people think you have to spend everything down on healthcare costs. While that is an option, not my favorite, there are ways for us to protect significant assets. If you're married, usually we can protect almost everything. And if you're widowed, single, divorced, not married, typically we can protect your house plus about half of the cash. We already talked about this a bit, but there's a myth, Medicaid, they can take your house. Well, I mean, that's not a myth. Medicaid can take your house. They will take your house if you don't do anything. But with the right documents in place, we can protect your house. There are special deeds that we can do in North Carolina that aren't even available in other states that let us protect your house immediately. I don't even have to wait 5 years to protect the house. I have clients right now that are in the nursing home, and we're doing these deeds for them this week, and their house will be protected. But someone has to let us know that that's going on, and we have to have the right language and a power of attorney so that if you're no longer competent, your agent can do this deed. I turn people away every week who just don't have the permission slip, who don't have the right language in their power of attorney for me to protect their home. So even if that is all you're doing with our office, that's pretty darn important. Let's make sure we have the ability to protect your house. So at the beginning, I gave you a few reasons why people don't get started. Procrastination. I can't really do much about that, but hopefully now you at least feel like you have the knowledge to make a decision. So really, we need a plan of action. And I'm here today to offer you that plan of action. We've been posting a link for a complimentary consultation with one of our attorneys. But we need an action plan. What do you need to do? How do we make it happen? When should we get started? And what is the investment? So we're very transparent. We're going to tell you what to expect when working with us. So at our firm, we have a philosophy about working with our clients. Because estate planning is just an extraordinarily complex area of law, we make it our business to maintain the highest level of expertise to handle the assets and the scenarios that we discussed today. But when it comes to getting advice, and trust me, there's a lot of advice out there, it's probably no surprise that you can get some information about estate planning from a variety of sources. So there's financial planners, there's advisors, CPAs, brokers. My favorite is the internet, and maybe even your friends or neighbors who are doing planning themselves. And although these folks might have expertise in one area that covers one piece of the picture, most likely, how it relates to them personally, they don't typically have an integrated, inclusive knowledge of what it takes to offer complete professional estate planning counsel. And the risky part, which could end up costing you a lot of money, is that they could be lacking the knowledge to handle the matters that are most critical to you, to your estate, to your heirs. So we believe that the success of our law firm rests on some of these core elements. So we have a passion for helping families plan. I mean, it's all we do. We have a strong comprehensive knowledge of estate planning issues. By focusing on this one area of law, we've really made it a point to become experts in this area of law. We have an amazing experienced staff with, people that have been here, some people over 20 years. And we like to have an ongoing relationship with your family. We offer a free consultation for all of the attendees of this webinar, so you know exactly what the plan is before you retain us. So our mission and our passion is legacy wealth planning, and it's to make a difference, one family at a time. We will create a customized estate plan designed just for you and your family, and we have set fees. And after signing the estate planning documents, you have 2 months to make free changes. We want to take the pressure off and make sure that you're really able to sit with this and feel good about it. So in our complimentary meeting, you're going to choose the best estate plan for your goals. And maybe that's a will, and maybe that's a trust, and maybe it's just that power of attorney, but we'll come up with a plan that makes the most sense for you. So the funny before the money, we're going to talk about fees, but you get what you pay for. And we really want to avoid bargains when it comes to parachutes, brain surgery, fire extinguishers, and definitely when it comes to estate planning. So our trust portfolio includes everything listed under these bullets. So you're going to have a revocable trust where we are going not only give you a revocable trust, but we're going to fund that trust. We are going to put your house and your assets and your personal property, everything goes in the trust. Again, I mentioned earlier, all it takes is one account to be left out and you're going through court. I don't find any attorneys locally that really do this for their clients. Why is that? It takes a lot of time. And I don't want to assume why anyone's doing anything, but attorneys stand to make a lot of money. I mentioned earlier, they get 2 to 5% when you're going through probate. They stand to make a lot off of a will. So you'll have a nice little owner's manual for your trust. We give all of our trust clients a will. It's called a pour over will. My hope is that never sees the light of day, because if it did, something was not in that trust and we're going to court. So we're going to make sure everything at the outset is funded to this trust. We give all of our trust clients a little plastic card with their trust information on it, so that going forward, and this is a question I get a lot, and I have some personal questions about this. There's no annual maintenance. As you get new assets, you take this card to the bank and you just make sure that assets are continually titled into the name of the trust. Now, we do have an annual maintenance program available if you're interested in hand holding. I met with somebody yesterday. They really want to know that they can come in anytime they want and not have consult fees. They want to know that they're not charged for phone calls. They want to know that, we're going to review assets every year. So we do have a maintenance program. It's $1,000 a year. Maybe one person watching this needs that level. A lot of our clients, we do this trust one time, and you'll let us know if we need to make changes in the future. We'll let you know if there's law changes. And while there would be fees for, an amendment 5 years in the future, as far as assets go, there's no fee for keeping those in the trust. That's just something that you'll need to make sure with that card that everything gets into the trust. But we'll help you at the outset. And usually I answer emails for no charge if you have a question on how this works. You'll get that power of attorney with the nursing home protection, all of the advanced directives, the health documents, healthcare power of attorney, HIPAA release. This is so that we can make sure your private information can be released so that your loved ones can pay your bills, make sure insurance covers it. So our trust portfolio is $6,450. This includes the deed to your house. So one North Carolina property is included in that price. Extra deeds, those will be quoted. Usually those are around $350 each, but if you just have one piece of property, for the trust, for the wills, for everything, we're looking at $6,450. This is whether you are married or single. This is one price really per family. If we do need to do nursing home protection at a later time, that is an additional amount. Normally those trusts are around $9,500. For most of you today, the fact that you were able to log on to this webinar, we're probably not at the point where you need a nursing home protection planning. For most of you, that power of attorney is going to be enough. That is what's going to allow me to protect assets later, even if we don't ever do one of those nursing home protection trusts. Our will portfolio includes a will, that wonderful power of attorney, all the healthcare documents. That's $2,100 each person. So if you're married, that's $4,200. So if you're doing a trust, I don't need you to add this to it. I don't need you to double the price of the trust. For a married couple, we're either looking at $6,450 for the trust or $4,200. Or if you're single, $6,450 for the trust or $2,100. And those are our two plans. So for the difference of a few $1,000s or a couple $1,000s, we can avoid court if that's something that's important to you. And if not, I totally understand. Some people are like, you know what? Yeah, there's gonna be a huge fee with probate, but I'm not gonna be alive to see it. And I totally get it. We're here to help your family, go through that process as well. So please don't put your head in the sand. You have the knowledge. So now I just really hope that you can take some action. Everybody who's attended this has a free initial consultation with the attorney. We also do have a financial advisor firm within our office called Wisdom Wealth Care. That's run by Linus and his son Logan. And actually my husband George is part of that as well. He was a CPA in another world, and he's decided to join us recently. So I know there's a lot of information about your estate planning choices, and this is where the seminar educational credit comes in. What we found is that when people come in to see us right after the seminar, all the information is fresh in their minds, and because they are equipped to make because of that, they're more equipped to make immediate decisions. And because it makes our job a little easier to not have to go through all of this with, 20, 40 different people, that is why we give out this credit. So we do ask that you come into the office within the next 2 weeks. We find that after that, this is just not fresh anymore. So we do have a consult fee. If you can't come in 2 weeks, you can come in 3 weeks. There is a $350 consult fee, and we'll waive it if you get started. So you won't pay that consult fee, as long as you get started. But if you just kind of want to give us have a meeting, give that a shot, hear what we have to say, we do ask that be made within 2 weeks. We do ask that all decision makers be present. So if you're married, both spouses need to attend. I always have somebody that says, me and my husband, we don't do any of our planning together. Now, if that's the case and you truly are your only decision maker, your spouse does not need to be there. But if you have joint bank accounts, and your spouse, you can't say yes without them, we really do request that they be there. And we're going to ask you to make a decision. Should we work together? Yes or no? We will ask that question at that meeting. Oops. So think of a free consultation as part 2 of today's seminar. Part 1 was free education in a group setting. Part 2 is a private meeting focused on the issues specific to your family. And part 2 is really for people who are ready to take care of their estate planning now, but maybe you just need more information to determine exactly what kind of estate plan that you need. If you're, just not really serious about doing this now, you don't need to request a consultation. We will not be offended. Maybe just let people know that we do this. That is thank you enough. Or maybe you want to talk to someone about unrelated advice, like your divorce or your traffic ticket or bankruptcy, your creditors. We don't do that here. We do estate planning. So I really hope this was helpful. And I'm going to hang on for a couple minutes. I'm going to go off video, but we are going to have an opportunity just to see if anyone asks any more questions. Again, we've been posting the link throughout, so please click on that if you would like a complimentary meeting. Also, we do plan to call everybody who doesn't sign up, just to make sure that they want to, if they want to meet with us. Some people aren't as technologically savvy, and I get it, so we'll be calling you. So don't worry if you can't get that link to work. So thank you so much for joining us today. Please take this opportunity to ask any questions, and I hope everybody has just a lovely rest of their day, evening. Well, I hope to see you in the next 2 weeks.